Very much. It has been a very long night, and I appreciate everybody's patience. And I'm going to start off by just reading a couple quotes that I want you to consider before I make my comment and motion. This first quote is back from April 16th of 2002. This, well, I wasn't on this board, but the Board of County Supervisors in 2002 had a special use permit for the Sedley Springs Worship Center. And a gentleman, my aide Michelle, spent hours over the weekend listening to a tape from 2002 with a public hearing, because clearly the Rural Crescent is a very passionate issue in Prince William County. And it was demonstrated tonight, the passion. So this gentleman, Jim Nichols, said, this is again for the Sedley Springs Worship Center, which was, I think it was also known as First Gainesville Baptist Church. What has fueled nearby resident concern is that the facility will be built in the Rural Crescent. Only one home per 10 acres is allowed, and the zoning laws prohibit sewer lines. Most people came out here to get away from this sort of project. And again, that was in 2002. And then, interesting enough, Michelle said that at the time it was Chairman Sean Connaughton who went on to be Virginia's Secretary of Transportation, which everybody up here on the board is very familiar with. He actually said that it was a very uncomfortable night because they had 51 or 52 residents from the Gainesville Haymarket area go and speak against this. In that particular faith, it was a Christian church, and he said it was a very uncomfortable night for him, and he didn't want to sit up here on the dais and experience anything ever like it again. Now, I imagine since then, Mr. Connaughton's had other uncomfortable meetings, but I just thought that was really interesting coming from somebody like him. And then the other quote that I want to read into the record that I think is important is regarding another SUP from almost 10 years ago. And it was a comment from a lady named Patty McKay. And Patty McKay is my planning commissioner. I appointed her to the planning commission because she has taught me a lot about land use. And I think it's interesting to say that in 2007, in December of 2007, Patty McKay, along with about 20 other residents who are advocates of the Rural Crescent, came to this meeting and spoke against Fireside Wesleyan Church SUP. They were requesting a sewer hookup as well. And Patty McKay on December 3rd, 2007 said, "This is not a referendum on religion. The comprehensive plan since 1998 has set the precedent that only existing homes and businesses with failing or pending failing septic systems could connect. You can support religion and the comp plan by allowing this institution to purchase a lot outside the Rural Crescent that has sewer connection for the construction of their church." So I want everybody to know that, again, the Rural Crescent has been a passionate issue, subject, whatever you want to call it, for years. And I just thought it was important to make that notation for the record. So I'm going to read a statement that I have prepared, and please bear with me. It'll just take a couple minutes. As an elected official, I value all the constituent input, and I appreciate that so many citizens have reached out to the board on this application. I ran for this seat because my predecessor had a totally different philosophy than I had on the Rural Crescent and development. He advocated for sewer and higher densities of residential development in the Rural Crescent. My positions from the very beginning when I first challenged the Brentsville District Supervisor in 2011 have been consistent on upholding our comprehensive plan and policies concerning the rural area. I also made a commitment to my constituents to engage the public on land use cases. I've received hundreds of emails on this particular project with concerns about the project's impact on the rural area and the effect on the comprehensive plan sewer policies. From my first day as supervisor, I have worked to uphold these campaign pledges by being firmly consistent. My concern regarding Adams do not reflect merely a single project stance. An important issue is that the Adams Center request for sewer goes against our comprehensive plan sewer policy. I will read to you from the planning staff report. Per the sewer policies in the comprehensive plan, the use, which is the Adams Center, does not meet the criteria necessary to grant the connection within the rural area, and therefore the staff would not recommend nor condition this connection. With few exceptions, development in the rural area shall occur without connection to public sewer facilities. For context, I also want to say that I am aware that there have been other potential applicants, including religious institution applications, that were very interested in developing in the rural area. I know personally that once they learned the comprehensive plan did not allow for sewer connection in the rural area out of respect for the policies, these potential applicants did not continue to pursue their interest in the rural area. Regardless of what anyone here has said outside of the land use concerns, this board is charged as public officials to look at the land use aspects. This is what we are assigned to do. There are things I heard tonight that I cannot consider because I'm just simply here to do my job. And my job is to look at the merits of the application and compare it to our policies, plans, and ordinances and base my decision on just that. Any other comments made outside of what I can address regarding land use in my official role will not and has not been considered. Previous proposals for various uses have come before me that raise similar concerns about intensity of use in the rural area. I expressed those concerns and steered them away from the rural area. If we are to preserve the rural area, we need to manage development and prevent the extension of sewer. This includes discouraging intensive uses which are best suited for the development area. The applicant has come to my office to meet with me twice since 2015. I expressed my concerns to them at that time and encouraged them to find a suitable location in the development area where they would not meet the challenges. Our sewer policy in the comprehensive plan is very clear. I've been consistent in my position and no sewer in the rural crescent and intensive uses in the rural crescent. I have not supported previous similar applications in the rural area. Our professional planning staff has been consistent in not recommending the connection to sewer in similar applications in the rural area as they did in this case. The Planning Commission concurred by not recommending the connection to public sewer. While there are specific exceptions, Adams has not yet demonstrated that any of those specific exceptions apply in this case. And it's not just about the sewer. The aforementioned comp plan has established policies beyond the sewer policy that encourage protection of the rural area, including the environmental, community design, and long-range land use sections. Managing land use through planning and zoning is the most cost-effective tool to minimize local property taxes, concentrating residential, commercial, and intensive community facilities in the development area minimizes both initial construction and long-term maintenance costs to local taxpayers. Our local taxes fund new schools, police and fire stations, libraries, parks, and other public infrastructures. Taxpayers have also had to finance new roads through bonds since VDOT has been unable to build roads fast enough to keep up with the traffic caused by sprawl. That's why protecting the rural crescent protects taxpayer wallets as well as protecting our scenic view sheds, our agricultural industry, our environment, and the rural character. Protecting the rural crescent isn't just about protecting it from residential development. It requires vigilance on all land use projects that propose to locate in the rural area. In summation, why should this board give advantage to an applicant when other potential applicants walked away with respect to our comprehensive plan policies regarding the rural crescent? It's not my job to take advantage to advantage or privilege any applicant. So with that, I will move forward the resolution that staff prepared tonight as written for SUP PLN 2014-00313.
Okay, is there a second?
Second.
All right, seconded by Mr. Canlon. Is there discussion?
Mr. Chairman.
Mr. Noy. No, sorry, Ms. Anderson.
I'd just like to say a couple of words. For the Occoquan District, I represent the Occoquan District, and I will tell you that we squabble over everything in the Occoquan District, from the location of a cell tower to cutting down a tree to the color of bricks on a building. So, and we might have many meetings over seemingly insignificant things. So this is nothing new to be concerned about something as big as this. For those of you that want to worship in a mosque, I seriously want you to find a good place. I want you to have a place of worship in an area where you would like to worship. I am offended, though, tonight that my vote, whichever way it is, could be perceived as whether I like a mosque or I don't like a mosque. It has nothing to do with that whatsoever. My vote has to do with land use issues and the ordinances that we have here in Prince William County. There were a lot of assumptions made when this land was purchased, and I don't know who did all the counseling, but we shouldn't be here tonight. We honestly should not have been through all of this tonight, because better work should have been done when they were selecting land for this facility. I do have major concerns. Traffic congestion is horrendous in the Occoquan District, so I can only imagine what the thoughts are of the people that live in this particular area. And I don't know why the land wasn't tested. That's a question I've had all night. Why don't we know what the situation is with that land and why it couldn't? We don't know whether it's appropriate for septic or not. So I'm going to go ahead and I will be voting yes for this resolution as it is here tonight.
Mr. Chairman.
Mr. Principe and then Mr. Noy.
Thank you. Well, you know, it's a good day in our community when nearly 1,000 people can come together here at McCourt and share their views about the proposed mosque under the First Amendment right of free speech. All of you were very articulate and very passionate about the issues. And one thing that stood out to me overwhelmingly is that we are talking past each other rather than to each other. Something happened in October of last year, about 8 or 9 months ago, when the community meetings stopped. They stopped. Why do I think that the dialogue was good? Because we heard the applicant say earlier, or last night, that they resubmitted 5 times because there was so much community feedback. Feedback was coming forward. The mosque leadership was listening. But something happened. I don't know what happened in October when the meeting stopped. So I think going forward, no matter how my colleagues and I vote on this tonight, going forward, I think we owe it to all of us to reinitiate that dialogue. If the mosque is approved tonight, with or without sewer, there's still steps in the process after we vote tonight where there's some decisions that still have to be made. Decisions still have to be made on the site plan, on the building permit, on the architectural features, even on sidewalk and street lights. Pedestrian safety is what I heard from some of you as well. So no matter how we vote, I think that it's just a shame that we stopped talking to each other and we started talking past each other. I'm going to vote no on Supervisor Lawson's motion, the staff resolution, because I'm going to vote in favor of the mosque and in favor of public access to sewer, and really hope that the right leadership is going to step forward and make this dialogue work, and we're going to work through the remainder of these issues together. Thank you, Mr. Chairman.
Thank you. Mr. Noe?
Thank you, Mr. Chairman. Appreciate the comments that everyone's made, certainly on this board, but really the 150 or so people who got up and spoke at this podium tonight. I was getting some texts during this, people saying, why don't you just cut them off? You've heard everything. People in this room actually were texting me saying, why don't you just tell people that we've heard everything we need to hear and we can move on? And my response to that is no, that we need to hear from everyone in this, because this is how a democracy works, is that the people have a chance to make their piece and say their piece before the elected body makes the final decision. And I'm really grateful for the fact that we had so much comment on this. I also recognize this is something where intelligent and reasonable people can disagree on some fine details of this. We've heard a lot tonight about the notion that some of the other religious institutions that have gotten sewer approval in different ways in the rural area are different than this, and I'll agree. And I look at Fireside Wesleyan Church, and I look at Park Valley, different situations, unequivocally. And there were a few others that I can't remember them all at this hour of the night. But I'll say this, from my perspective, there's one thing that didn't make them different. I voted for all of those, and I didn't vote for them because of that tiny little difference. I voted for those because I believe that while it's important that we have guidelines in our comprehensive plan, and that we have rules, the reason we built into those rules the ability to have this conversation and make exceptions is because sometimes we need to. And I believe that the most fundamental reason for us to have to make a change is because of the God-given and constitutionally protected right to practice freedom of religion. It is embedded in everything we believe in this country. And as much as I am sympathetic to those who would say that a sewer connection is a worm into that's going to a vine that's going to attack other things, that has not been the case in the examples of the other religious institutions we have approved. And I believe that if there's any time that you're going to make an exception, it has to be for religious purposes. Mr. Chairman, I would like to make a substitute motion to Mrs. Lawson's motion to approve this case, but with an amendment to condition 12 to remove the requirement that it connect to septic and allow it to be connected to sewer.
Is there a second?
Second.
Seconded by Mr. Prinsby. Okay, now discussion on the substitute motion.
Yeah, Mr. Chairman, I think
Callan.
thank you. I think I'll chime into this. Just to Supervisor Noe's point, that the concern, the issue that, well, it doesn't really lead to anything. Well, the problem is it does, because it's led to tonight. It's led to, we've got a situation where we are having a proposal that is looking to disregard a pretty significant, it's not like whether you can have outdoor storage in an M1 versus M2. Sewer is a pretty significant component of the rural crescent, probably the most significant component of it. The crux of the ability to expand facilities, the crux of the ability to expand neighborhoods. You take out the sewer component of the rural crescent, and you really don't have the rural crescent. Now, I feel honored to serve as the Gainesville supervisor, but part of that responsibility of serving as the Gainesville supervisor, and I know Supervisor Lawson has that responsibility also, is we're almost the sentinel standing there on the rural crescent, because so much of our district has the rural crescent in there. So we get very sensitive and want to make sure that we're very specific and careful when it comes to the rural crescent. For those of you folks who are seeing these proceedings and thinks, well, they're picking on us here because they're talking about the rural crescent, I invite you to come to a lot more of these meetings, because we talk about the rural crescent, we talk about sewer, we talk about traffic, we talk about these kind of things all the time. And we have these issues, and frankly, we have other constituent groups who come out here and we have vigorous debate about it. So this isn't an unusual discussion. Someone made the comment several hours ago about consistency. We want to make sure that we have consistency. You know what? One of the reasons that you don't hear about a lot of churches or other facilities getting denied public sewer from the board is because they don't make it this far. because when churches come in or other facilities come in and we let them know this is not permissible, for example, the extensive conversations I had with the Catherine Drexel Church, where they came and talked to me and said, we would like to put in or get public sewer for our facility. And I said, I cannot support that. It's something I cannot support. So they, and the community loudly said, we do not support that. And so the Catherine Drexel Church said, okay, we're not going to put that part of our application. So you see the ones where organizations move forward, but you're not seeing the dozens and dozens that never get to this point because they end up saying, okay, this isn't a part of the Rural Crescent. Now, there are exceptions. We definitely understand there are exceptions. One, Victory Crossing was one that this board decided to make an exception, but we felt at the time there was a very good reason. It does concern me that there wasn't any sort of, at least a token effort that I saw to make a case why there should be an exception besides the point that, well, you've done it before. Well, we've done it before because very specific exceptions were outlined and brought to the board and said, this is why we can't have septic. And I didn't hear that. I think it could have been a different situation if there was, we had a soil test done or something that we could hang our hats on that this is something that needs an exception. I am in favor of Supervisor Lawson's original motion to approve it, but abiding by the regulations of the Rural Crescent, the guidelines of the Rural Crescent that many of us have promised to uphold. And so that's why I won't be supporting Supervisor Noe's motion to have public sewer.
Okay. Yeah, Mr. Jenkins?
Yeah, Michael. I, too, am going to support Janine's motion for approval. And I had a lot of concerns about how I was going to get to that position of taking or making a decision, frankly, on either or, because there were so many problems that I saw with infrastructure and compliance with a comprehensive plan. We have a law on the books, and it's incorporated in the plans of the county government called a comprehensive plan. And in effect, if we go against the comprehensive plan when we are processing various applications for special use permits or rezonings, if we go against the comprehensive plan, we're just violating the law. But on the other hand, if you don't make an exception every now and then in that part of the plan that gives some discretion to the Board of Supervisors, then you're not ever going to get where you need to go anyway. So that's what I'm going to do. Is my vote will be for her motion, but that's going to be without the sewer, because Ms. Cadigan and I, a number of years ago, fought the battle of the comprehensive plan, and I don't think we have to revisit that. I just don't think sewer is appropriate because of the fact that we are violating the comprehensive plan.
Could we get the county attorney representative up to the podium, please?
Thank you, Mr. Chairman. Senior Assistant County Attorney Kurt Spear is coming to the podium now.
Okay. While he's making his way down there, as you all know and a lot of you have recognized, this is not a normal land use hearing. The board's normal powers, rezoning powers, are restricted in this case because it is a religious institution. We are limited here by the federal law, specifically the Religious Land Use and Institutional Persons Act. So I have a couple of questions about that act.
Yes, sir.
And I know you can't give legal advice here in public. You can give it to the board closed session, but not advice, so I just want to ask about the law and the way the law has been interpreted over the years, and how it would be interpreted in this case. So that's what I want to understand. So with regard to, there are two provisions of RLUIPA that I understand that are potentially applicable, and one is the discrimination clause, and the other one is the substantial burden clause. Is that correct?
Yes, those are two of the four prongs of RLUIPA. One being that a state or local government in the exercise of its land use regulations cannot impose a substantial burden on religious exercise unless that burden is the least restrictive means of furthering a compelling governmental interest. The non-discrimination provision simply says that local government cannot discriminate through the implementation of its land use ordinances against any particular religion or religious denomination. There are also two other prongs of the statute. A locality cannot have a total prohibition of religious institutions or place, quote-unquote, unreasonable limitations on the location of religious institutions.
And those are inapplicable here, I understand that. But tell us again the rule with regard to substantial burden.
The rule is a local government cannot impose a substantial burden on the religious exercise of an individual or religious assembly or institution unless that burden is the least restrictive means of furthering a compelling governmental interest.
Okay. So if there is a policy that is a burden, but it's consistently applied, then what does case law say with regard to whether or not that constitutes a substantial burden?
I mean, it depends on what that particular policy is, but generally speaking, if you're a locality and you're applying a facially neutral policy in a consistent manner across all religions and religious denominations, as well as for religious uses versus non-religious uses, generally speaking, courts have found that that does not constitute a substantial burden.
Okay. So if it's consistent, it's not a substantial burden.
Generally, yes.
Generally. Now, what if the policy is inconsistently applied? Even if you have the policy, but it's inconsistently applied.
And in those cases, the localities have not fared so well.
All right. Which means what? They haven't fared so well, so what happened in that case, those cases?
Well, courts are much more likely to find a substantial burden and will do so on a much quicker basis if a court has evidence before it that a locality is applying a policy or an ordinance or regulation in an inconsistent manner. Essentially, if it applies that policy in some cases and does not apply it in others.
Okay. So in Prince William County, have we approved churches in the Rural Crescent with sewer?
I know of, in terms of legislative actions taken by the board, the two that I know of are Fireside Wesleyan and Victory's Crossing, which have been mentioned tonight.
Okay. And in the case of Victory's Crossing, which the board just approved in 2013, did the board make any policy statements within that resolution with regard to religious institutions in the Rural Crescent? And also, did the board make any policy statements within that resolution concerning the presence of churches with sewer in the Rural Crescent?
The board's resolution, which I do have a copy of, it's from September the 10th of 2013. The board did make several findings in granting the sewer extension. There were 8 specific findings that were made by the board. One, that the proposed institutional assembly use is an appropriate land use in the rural area.
Meaning the church?
Yes.
Okay.
Number 2, on-site septic systems are ill-suited for such uses, which have erratic sewage system usage.
Okay. I'm sorry, say that again. So the septic systems are ill-suited?
Are ill-suited for such uses, which have erratic sewage system usage.
Okay, so we made, in that specific case, whatever the policy was up to that point, the board in this case made an exception specifically and said that we're going to approve this church with sewer, and they also made that policy statement that septic systems are ill-suited for the Rural Crescent. for an institution like that, meaning like a religious institution or something large.
That's what the resolution says.
Okay. All right. So that's go ahead, Mr. Jenkins.
So that means now that my recommendation is accepted on the no sewer.
What I think this means, and I'm the only lawyer left. I'm an endangered species on this board. And I can't give you legal advice, but my understanding of that is that the board has not consistently applied a policy position against religious institutions and against sewer in the rural Crescent. And I think, based upon that, that there's a prima facie case that we would be applying to the mosque a policy that we have not applied to another religious institution in the rural Crescent. And therefore, it would be considered a substantial burden. So that's my understanding. Now, before I give up the floor here to anybody else, I want to go to the other provision of RLUIPA, and that is the discrimination clause. So, how many cases? Again, how many cases have we? You already said we've considered at least 2 that you can remember. What was the first one?
Fireside Wesleyan, which I believe was approved in 2007, and Victory's Crossing in 2013.
Okay, so we've considered 2 Christian churches in the rural Crescent with sewer, and we approved both, correct?
Those 2 were approved. I don't know of any others where the applicant made the specific ask of the board.
But I want to stick to churches here because it's specifically relevant. So okay, Mr. Jenkins, you want to withdraw your statement? Okay.
I'll be okay on going forward with a yes.
Microphone, sir.
Well, I wanted to withdraw my subsequent motion, but I'll be okay with going with a yes vote on the motion.
With Mr. Noe's motion?
With
Mr. Noe made a substitute motion
Yeah.
which would approve the mosque with the sewer.
That's the one I want to withdraw.
Okay, thank you. I think I'll leave it there.
Mr. Chairman,
I'm sorry, Ms. Lawson?
thank you. Kurt, Mr. Spear, sorry, it's 3 in the morning. Has our district ruled on any of these cases that you're referring to, our federal district court?
When you say these cases,
The RLUIPA ones that you're referring to, the case law, when Chairman Stewart was just asking you?
yeah, there, in terms of the Fourth Circuit Court of Appeals, on the substantial burden provision, there have been 2 rulings of the Fourth Circuit. The first came in approximately 2013. It was in a case called Bethel World Outreach.
Okay. I'm sorry, it's 3 in the morning.
Okay.
I just want to keep it simple. What I'm remembering is there was a case in Newport News.
Andon versus City of Newport News.
Okay. Yes. What were the findings of that case?
In that case, it involved a variance request that was submitted to the City of Newport News. Church had bought a piece of property. They needed to obtain a variance from a setback regulation in order to get the approval necessary to construct the church. The district court, affirmed by the Fourth Circuit Court, ruled that because the property was purchased with knowledge that there was need for a setback, that there was no substantial burden in that case because essentially the court viewed it as a quote-unquote self-imposed hardship.
Okay, so if I understand you correctly, that was a case that the church lost.
Yes.
On the substantial burden.
Yes. In terms of on the substantial burden case from the Fourth Circuit Court of Appeals, localities and churches are 1 and 1. Let's put it that way.
Okay.
Yeah, and there are other cases that are district court level cases, which have interpreted the substantial burden provision at some stage of the proceeding. Most recently, the one in Culpeper County, where Culpeper's motion was dismissed, and the court found that the facts as pled in that case would establish a violation of the substantial burden provision of RLUIPA.
Okay. I'm sorry. I have a train of thought. I don't want to lose it. But thank you. The Newport News one is the case I was specifically referring to, and I'm going to reiterate because it's 3 in the morning. the church did not win that case on substantial burden, correct?
That's correct.
Okay, thank you. That's important to know. And it's my understanding, and I'm going to put her on the spot here at 3 a.m, the planning director, I'd like her to, we've worked a lot with her on, this is Rebecca Horner. And Rebecca, what's your opinion about this particular substantial burden and and our comprehensive plan sewer policy?
Thank you, Mr. Chairman, members of the board. Rebecca Horner with the Planning Office. Our staff report outlines the sewer policy. The staff recommendation is denial based on the board's adopted policy for sewer connections.
And has the staff always been consistent on that regardless of the applicant?
To my recollection, yes.
Okay. Do you believe, well, never mind, you're not an attorney. Thank you.
But what is, again, for the county attorney, what matters here? What the board did, the decision maker, or the recommendation of the staff? What's important to the court?
Both. Courts will look at the board's action, obviously, because ultimately that's what determines the rights that the applicant has at the end of the day. But courts, one of the things that they will look at in determining whether or not a locality's action is reasonable is what the recommendations of a staff are. Particularly in the case where, in situations where you've had staff recommendations of approval and the board has taken actions that affected denials, again, localities have not fared well in those cases, to be sure.
Yeah. So let me ask you this, Kurt. With regard to the discrimination clause, is the standard whether or not there was a difference with regard to treatment by the decision maker, the board, or does the plaintiff have to prove an intent to discriminate?
In the cases, and there are not as many cases on the non-discrimination clause, but the cases that I am familiar with, there has been no necessity for finding discriminatory intent. Essentially, disparate treatment has been enough for at least 2 district courts that I know of, the one in Western District of Virginia on the Culpeper case, and recently the Basking Ridge case in New Jersey. And
has the court gone in depth into the nuances of what the differences were, or did they just kind of say, look, here was a church, it was approved, here was a mosque, it wasn't approved, in a rural area or something like that?
I don't know of anywhere where location in the rural area has necessarily been the determining factor. The court in New Jersey took a very deep dive. The one in the Western District of Virginia in the Culpeper case, much less so. In terms of the Culpeper case, it really seemed to turn on the perception of the court that the permit that was applied for in that case was a permanent pump and haul permit. Those had to be approved by the Board of Supervisors in Culpeper County. There's a discrepancy between some of the news reports. Some say 19 out of 20 permits had been approved. Some say 26 in a row had been approved. But in either case, one of the findings that the court made in Culpeper, both on the substantial burden provision and on the non-discrimination provision, was that the fact that the permits had traditionally been granted with very little scrutiny, essentially the court's determination was that was reflective of both the fact that there was a substantial burden imposed because the mosque in that case was being asked to do things that other religious institutions weren't asked to do, that were much more burdensome, and a violation of the non-discrimination provision because essentially they were treating the mosque in a different manner than they had treated at least, I can't remember if the number was 6 or 9, but several Christian churches that had applied for and received the same type of permit.
Okay, so we're discussing the substitute motion made by Mr. Noe, seconded by Mr. Principe. And if this passes, it will become the main motion, so there will be another vote after this. So is there further discussion on the substitute motion?
I do.
Yeah,
I haven't said anything all evening. Been listening and been very busy all day, all week. In all of my years on the board, and I've been on many years, I've never voted against a church, and I had always this evening planned to vote for the mosque. I felt that that was important, and I have visited the mosque on Spriggs Road, and I have enjoyed it very much. However, in listening to, and then I understand that Patriot and the 2 elementary schools have SOAR, and the 2 churches that have received exceptions, and so now I feel that I want to support Mr. Noe's motion because I want to be fair. If exceptions have been made and we're not going to do it on this mosque, I was always going to vote for the mosque because I think you are people of faith and you want a place to pray, and I understand that. And you've always been very involved in the community. I've seen that firsthand. But the SOAR I've thought about. The Rural Crescent, I will always be there for the Rural Crescent, and I just think I want fairness. 2 churches, a high school and 2 elementary schools have received the SOAR, and I want to be fair. So I'm going to vote for Mr. Noe's motion.
Let's vote on the substitute, Mr. Noe's substitute motion, which I'm going to be supporting. Please vote.
The motion fails because it's a tie vote 4-4, but it's Supervisors Cadigan, Noe, Principe, and Stewart voting aye. Supervisors Anderson, Canlin, pardon me, I'm writing at the same time, Jenkins and Lawson voting nay, so it is a tie vote, so the motion to amend fails. So the main motion before you is the one
Mr. Chairman?
by Supervisor Lawson.
I move forward my motion for approval.
Okay, is there discussion on the main motion? Mr. Noe?
I just want to make one observation. I disappointed by the outcome of the vote, but it's how democracy works. I want to say that it was suggested earlier this evening that the board might vote in favor of SOAR because we were afraid of a lawsuit. We did have some discussion of that. I think the question of a lawsuit is relevant. From my perspective, I did not vote for SOAR because I was afraid of a lawsuit. I voted for SOAR because I believed it was the right thing to do. I still believe it's the right thing to do in this case, but the board has not gone down that path. I'm going to vote in favor of Ms. Lawson's motion because given where we are, I also believe it's the right thing to do. And because I believe we need to do what we can to move this mosque forward. So.
Okay, are there any other further substitute motions?
Mr. Chairman?
Yes, Mr. Principe?
I'd move to divide the resolution and consider the 2 issues separately.
Okay, there's been a motion for division. That is, I believe, Ms. Roble? I think that is permitted under the board's rules, is it not?
I think it's non-debatable, if I'm not mistaken.
Okay, there's been a motion to divide
the question.
Divide the question. And this would divide the question from, just to be clear, the question of the sewer from the approval of the mosque. We'll be voting on these things separately.
That's correct, and we would start with the mosque.
Mr. Chairman?
This is not debatable. Ms. Lawson?
I just had a question. Isn't this exactly what we just went through?
No, that was a substitute motion. This is a motion to divide the question.
It's different.
Okay, this is a good idea. I think this clarifies. This is a very good idea to divide the question. Let's vote on the motion to divide the question. A second by Mr. Noe. Please vote on the division of the question.
Mosque.
Wait. On whether to divide the question.
Yes, whether to divide the question.
Well, Mr.
Chairman.
Chairman,
Yes.
if it's non-debatable, we're not going to vote on whether or not we can divide the question. The vote is on the mosque itself, and then the access to sewer. And if I can just get clarification from Mr. Campbell.
Mr. Campbell, do we have to vote on the division of the question?
The only time I don't have my
Okay,
books out.
go ahead. You figure it out because this has your answer must be correct. Ms. Roble, it's probably in Robert's rules.
It is definitely wrong.
Yeah.
Mr. Roberts has no sense of humor. Motion to divide the question is an incidental motion. It It does not require a second. It can be amended. It is not debatable, and it needs 2/3 majority vote
What needs 2/3 majority vote?
to divide the question.
Seems like
I thought you said we don't vote on it.
No, that's not what I said. I said it does not require a second. It can be amended. It is not debatable, but it requires a 2/3 majority vote.
You might want to keep that book open.
This is the county attorney's handout. Did you want to take it?
I was just going to say, has that provision been adopted into the board's rules of procedure?
Mr.
The
Chairman.
board's rules of procedure are that we follow Robert's Rules of Order.
If it's not there, but the board's rules of procedure
Do not address.
do not
Okay, I'm going to
address-
call a recess for 10 minutes, and I want the clerk and the county attorney to figure this out and come back with a definite answer.
10 minutes?
10 minutes.
Mark down 10 minutes.
We're back on the show here. Okay, welcome back, everybody. Thanks for the recess. So why don't we have the county attorney explain what was,
If she were there.
if she's there. We very rarely have to use Robert's rules.
And they're hard when you use them. They're not fun.
But this was confusing. Okay, Ms. Rowell, would you like to explain what is required for dividing the question?
Thank you, Mr. Chairman. To divide the question, the board simply needs a majority vote to divide the question.
Oh, okay, so we have a motion. This is not debatable, correct?
Correct.
Not debatable. There is a motion by Mr. Principe to divide the question between the mosque and sewer for the mosque. Is that correct, Mr. Principe?
That's correct.
Okay, there is no debate. So please vote on the motion, Mr. Principe's motion to divide the question.
Mr. Chairman, can I ask the county attorney something?
You may ask the county attorney
Okay, no,
something.
I'm not debating.
All right.
What's the purpose of dividing a question? I'm a little unclear on that. If we're
So you can vote separately on two
but if
different parts of the
everyone's
question.
if everyone's in agreement on the first point of it, and we're just in agreement or disagreement on the second point of it, what's the
We're
purpose
getting
of
into a
dividing
debate
question?
here, right?
Well, answer.
Robert's rules provides that if a resolution has several prongs to it, that the governing body is entitled to divide them and vote on them separately.
Okay, please vote. This is the division of the question.
Division. The answer is yes.
Motion passes 5 in favor, 3 opposed. Supervisors Cadigan, Jenkins, Noe, Principe, and Stewart voting aye. Supervisors Anderson, Canlin, and Lawson voting nay. So the motion to divide the question passes.
Okay, now, the first question is on approval of the mosque itself. Is there a motion on the approval
So
of the
moved.
mosque itself?
So moved.
Just discussion. Ms. Anderson.
I just want to know if this first one passes, what is the second motion exactly?
The second question is whether or not the sewer will be approved with the mosque.
Public access to sewer.
So right now we're voting on the mosque.
Yes.
Call the question.
Okay, please vote.
Vote unanimous to approve the mosque.
Okay. Now do we have a motion on the approval of the sewer?
So moved.
Discussion? Okay, please vote. Please vote. Please, all right, please vote again.
It's a tie vote 4-4.
Wait, I think, Mr. Jenkins, did you, because I think you voted inconsistent there.
Mr. Chairman,
Do you want to? All right. Okay, we need a motion, for those who voted in favor, we need a vote to reconsider.
So moved.
Mr. Chairman, can I?
I'm sorry, well, there's been a motion to reconsider. Is there a second on the motion to reconsider? Okay, is there discussion on the motion to reconsider?
Yeah, Mr. Chairman,
Yes.
how can we have a motion to reconsider when it was a 4-4 vote? That means it should have failed.
Anybody who voted in favor can make a motion to reconsider.
Mr. Chairman, I'd like the clerk to rule on that. And then I'd also like to know when we're going to get back to my original motion, which was after the...
We divided the question. We divided your
Right.
motion.
Right.
Mr.
It
Chairman.
looks like I'm looking to
Mr.
the county
Cameron?
attorney.
I think let's kind of take a step back here for a second. So what ended up happening is we took Supervisor Lawson's motion, divided it up. We all were supportive of the mosque, so we got that out of the way. And now the question is on public sewer. And I think Supervisor Jenkins has been very consistent that he's not in favor of public sewer going to the rural crescent. And I think that's what you saw why he voted no.
There's a motion to reconsider. Is there further discussion on the motion to reconsider? Please vote on the motion to reconsider.
John, yes.
Please vote on the motion to reconsider. Please vote yes on the motion to reconsider.
Mr. Jenkins, sir, would you care to vote, sir?
Mr. Jenkins? No, please vote on the motion, John. Please vote yes. Yeah. I'm supporting the motion, Mr. Jenkins. Okay.
Mr. Jenkins voting aye, the motion passes.
Okay, now we have a motion.
Passes 5 in favor.
Okay, the motion to reconsider has been passed. Now we need another motion.
How about the motion to adjourn?
No. We got to get done with this, guys. We got to get done. We need a motion. Again, this is a motion on the sewer.
So moved.
Okay, is there discussion? I'm going to vote yes on this. Please vote. Please vote.
Mr. Chairman, just so I'm clear.
Yes, of course.
This is whether to allow public sewer for this situation.
That's correct.
Okay.
The motion passes 5 in favor, 3 opposed. Supervisors Cadigan, Jenkins, Noe, Principe, and Stewart voting aye. Supervisors Anderson, Canlin, and Lawson voting nay. So the motion.
Please clear the board. We need a motion to adjourn, please.
So moved.
Discussion,
Please vote.
Mr. Chairman.
There's no a motion to adjourn. There's no motion. There's no discussion. A motion to adjourn. Please vote.
That was really bad.
Pete. Who seconded the motion to adjourn?
Who seconded the motion? He did.
Ms. Anderson? Ms. Anderson and Mr. Jenkins, would you care to vote to adjourn?
John, this is a motion to adjourn. John, it's a motion to adjourn. Yeah.
The motion passes 7 in favor, 1
right,
opposed.
we're done.
Supervisor Anderson, Cadigan, Jenkins, Lawson, Noe, Principe, and Stewart voting aye.